if you write an aspirational statement like, we will always treat each other with dignity, everyone in the workplace is expected to treat each other with dignity in your contract of employment, it may improve behaviour slightly, but it's not going to get it to 100%. It's not even a particularly good way of changing behaviour. It's not the topic for tonight, but just in order to avoid being too negative, I will point out that there are lots of really effective ways that you can change behaviour in a workplace, not through the contract, modelling by management, clear statements to individual employees, coaching, monitoring, achievable goals, non-financial rewards, including feedback. I mean, these things are incredibly valuable, and those of you in HR will be well aware of that, and that's something that some of you who've attended some of our performance management seminars will be aware. We're not saying just give up on how people behave, but I am saying incredibly strongly, do not put it in your contract of employment. What happens if you have an aspirational statement in a contract of employment is you could well end up in serious breach of contract litigation. So a couple of examples that I'm going to take you through, and not to create too much fear, but just to show you how a few really minor words can, for the employer, go terribly wrong. A quite famous case where Goldman Sachs had in their workplace policy, which was held by the court to be incorporated into the contract of employment, a statement that JB Weir will take every practical step to provide and maintain a safe and healthy work environment for all people, which is obviously a great thing, but it was in the wrong place. What happened was, as is often the case, a couple of salesmen had disputation between them. There was particular disputation between Nikola Vich, the employee here, and his manager. The employee developed a serious stress condition. It was found by which he had to give up his job. It was found by the court that that was contributed to by the workplace, and that the company had breached the contract of employment because it had failed to provide and maintain a safe and healthy work environment. The damages were $450,000 because he was on quite a high salary. Now, without that term, it would have been a matter for workers' compensation. Now, we can, there's different views about how the workers' compensation system, whether it's become very ungenerous, etc., or whether it's the appropriate, is at the appropriate balance right now. But what you certainly don't want to end up in is a situation where you've got a breach of contract claim, where you're ending up with those unlimited damages or damages equal to what you've actually lost. Because there have been cases and situations in the workplace quite regularly where people end up with a stress condition in particular, which prevents them from ever working again. So there can be huge amounts of damages. So whilst as an employer or an HR manager, it is always your job to do everything possible to maintain a healthy work environment for everyone and never give up on that objective. You've got obligations under the Work Health and Safety Act, etc. Do not promise it in your policies or contracts of employment. Another example, which is quite recent and has surprised some people to a certain extent, was a decision where, a recent decision just from last year, where the workplace policy said, and the employee's letter of engagement said, all policies will be observed at all times. It didn't say the company would or the employee would, it just said all policies will be observed at all times. The workplace policy that became an issue was the complaint and bullying policy. The bullying, the applicant in the case put in a formal complaint under the policy. The employer did not follow, as is often the case, but did not follow the procedures in their own policy, ended up in a breach of contract claim, which the applicant won. And it all came from the words in the letter of engagement that the policies would be observed at all time, which was taken to mean by everyone, including the employer. And as happens in, I don't even think we'd say say 99% of workplaces, 100% of workplaces, the policies are not observed at all time. It never happens. It's an impractical goal.
A good example is something like a bullying policy, which most employers now either have or are creating because they realise if they don't have it, then they may end up in the commission. So you want to have a policy, you just don't want to be absolutely bound to the steps. And I mean, even within the policies, you want to have some flexibility in terms of wording.
Because workplaces are filled with human beings. They're not robots, unfortunately, so they will not be able to follow them.
One day they will be, Helen.
Possibly. But, I mean, the only reference you should have to policies in your contract of employment is a clear statement that your policies are not incorporated into the contract of employment, but the employee must comply with them, and the employer can change them from time to time. So what you're trying to do in your contract, as Lucian said in the opening, is take back some power. The Fair Work Act and the awards are there with some power for the employees. You want to give yourself as much power as possible. That doesn't mean you'll always exercise it, but you want to have the right. You don't want to be constrained. You want to be able to, in terms of the notice point, which is so critical that Lucian talked about, you want to be able to say to that 55-year-old employee that's leaving because of a mutual decision, we've decided to give you 6 months, here's the deed of release. You don't want him saying you have to pay me 2 years. That's what you want. But Vivi Financial Services Australia had a contract of employment with their employee, senior financial controller, where they included the right to terminate for cause, but they included a clause that said the company agrees not to terminate the executive's employment without bringing to notice an alleged breach and giving him an opportunity to respond before the decision is made, and this is particularly powerful, making the decision in good faith based on the factual material before them. Now, obviously that is great. And you have to wait. Or not. And everyone should operate like that. I'm not advocating not operating like that, but it's an incredibly onerous obligation to put on yourself as an employer. In this case, Mr. Vivi had not Mr. Vivi, Mr. Sharma, Vivi was the company, had a $1.4 million retention amount that he was going to become due to receive. The allegations were made of sexual harassment against him. The company purported to terminate him for cause without giving him a proper opportunity to respond, and there was a suggestion that they did it not in good faith. Ultimately, the court, at both the first instance and in the Court of Appeal, found that the company had not discharged the onerous obligations that they'd agreed to in the contract, and therefore the termination of his employment was not valid. He got the 1.4 million. The only reason I say I'm not sure, I know nothing about the case, other than what I've read in the judgments, and you do wonder if there was an element where they jumped on this allegation. That's what I wanted, to just terminate him because they really want to save the 1.4 million. I don't know. So there is something, whether justice ended up being done, who knows. But it is a very pertinent lesson about what should not be in a contract of employment, and certainly any references to acting in good faith or anything like that should not be included. There's some implied obligations of good faith, but don't give them to yourself because they're really hard to comply with.
So do the policies then have any enforceability or breaches opening you up to disciplinary action under the contract? Or?
Well, the policies do have some legal impact, not in the contract, if the contracts are done properly, but they have some quite significant legal impacts. So you have to be careful how you word your policies as well. But, for example, a performance management and discipline policy, if you end up in a Fair Work Act unfair dismissal case, the extent to which you've complied with that will be a relevant factor, without doubt. Sexual harassment policies, policies around work health and safety, all of those issues where you have obligations at statute law, significant obligations as an employer. What is in your policy is a two-edged sword. Having the policy, doing training about the policy gives you some protection against vicarious liability in relation to the conduct of employees and can help in certain circumstances to demonstrate compliance with your statutory obligations. However, and unfortunately this is more I've seen more of the downside, a failure by you to comply with your policies can sometimes be an admission in effect that you haven't met the statutory obligation. So I say have the policies, have the training, have all of that to make sure that you're doing your very best to comply so you don't get into trouble, and then if you do get into trouble, something goes wrong, you can show that you've done your best. But again, be very careful to have any policy which you can't comply with, because that can just be an admission of, you know, work health and safety breach or unfair dismissal if you didn't comply with your policy. So, but they are important to have, but keep them short. We'll get an answer. You know, what we're going to get into, what I want to talk about is situations where the contract says there will be a position description which will be agreed in the first month. There will be an incentive scheme under which you can earn up to 40% of your pay, which will be agreed in the first month. Agreement to agree creates a really difficult situation in an employment environment. Often it can be difficult, like if you're the employee going for a job as a salesperson, you don't want to have agree what your incentive scheme is. You want to know exactly what it is. But by the same token, as an employer, you want to be very careful about a position where an important term has not been specified beforehand, because what if you can't agree? The case Lucienne was talking about with the Susanna Marr case, they were trying to change the contract and she wouldn't accept it. Once you actually start, you have a contract in place. And if it's not set out what the terms are, and one of the key ones being remuneration or position description, you are not completely entitled as the employer to just say this is what it is going to be. So do not have anything that says we will agree what the terms are going to be. With incentive schemes in particular, there's even a danger in saying you have an incentive scheme where if you meet certain objectives, you can earn up to 40% of pay, but we will stipulate those goals. Whilst that's better than an agreement to agree, unfortunately what happens is the goals are not actually stipulated. They have nothing to work towards. The obligation is entirely on the employer to stipulate those goals, and you can end up with no benefit whatsoever and the right of that employee to say, well, I've got lost opportunity damages, which they would be entitled to up to 40% because I had no chance. So incentive schemes are incredibly important and valuable, and they can be, you know, a major part of remuneration for many people, particularly in sales, and highly motivating. But when someone's starting out and you're doing the contract of employment, do not have an agreement to agree about the incentive scheme, and do not put the obligation on the employer in relation to setting the goals. Both of those are a problem. What you need to do is either have a clause, depending upon the position and how important the incentive scheme is and time pressures, you can have a clause that says any incentive scheme will be entirely discretionary. That is particularly disincentivizing for the employee. So if it's a high part of their employment, if their remuneration, you'll find that a very negative ongoing work arrangement. You set out a minimum entitlement in the contract with the capacity to have more per agreement. The other alternative is you actually do have the policy, whether it's a short-term, long-term incentive, at the same time as doing the agreement. If you've got ongoing employees with incentive schemes, I think it's really important to have in the contract that there'll be no right to payment if you've given notice and you've left. That doesn't mean you might not agree, but it's one of the big issues that comes up all the time, and it's really important to be clear that if the person's gone, if the payment comes in or that there's something crystallises for them to be entitled to it, they won't get it. And then, for example, some companies do, and this works really well, a yearly, say, or a half-yearly incentive scheme. So which is in writing and clear, and is not part of the written contract of employment in the sense that it is written at the time, but it is a completely binding document that everybody sticks to and provides great incentives to the company. And that's actually a very good way to go. But it's important to have in your original contract of employment, when you have that you have a right to change the scheme from year to year, and you have a right to set new goals, etc.